All right, there's Mr. Shop. All right, are we ready for the jury?
No, Judge, can we approach?
Okay.
Yes, a friend of my wife.
Okay. So you actually know this person because she's a friend of your wife. How well do you know her?
She actually played football with my wife.
Flag football, I presume?
No, it was professional full tackle football.
Oh, really? Okay.
That's all it was, yes.
All right.
Yeah, they were both members of the Tampa Bay tournament.
Okay. And what sort of conversation did you have over
We were talking
lunch?
about us. Excuse me, I'm not taken back by this.
It's all right. Just relax.
We were talking about my son that she knew when he was kindergartner, and I explained to her how much bigger he is now. He's much taller than me now, and what career path he's chosen to take, and that I get to take him to New York to go to school in Pottersville, New York, in 2-3 weeks.
Okay. Now, did you all talk about the case at all?
No,
Okay. Did she indicate why she was even here in the courthouse?
no, sir.
Okay, did you ask her why she was here?
No. I just took her as a friend of my wife. Well, we were friends too. Through football.
Okay. How long have you known her?
Well, at the time that I knew her for about 2 seasons, actually. Just 2 seasons. Yes, 2 seasons. And my wife and her played flag football together as well.
Okay. Okay, so she didn't say why she was here and you didn't ask her why
I
she
didn't
was
really
here?
know why she was here. Curiosity didn't take over me. I just saw a really good friend from the past.
Okay. And what was her name?
Ellie Coffee.
Okay.
What was that? I'm sorry.
Ellie Coffee.
Ellie Coffee?
All right. State, you have any questions?
Yeah.
All right. Does the defense have any questions?
No questions, Your
All
Honor.
right. All right. Thank you, sir. You can go back with the others. All right. Any?
Your Honor, it was represented that she was the president of the NAACP.
That wasn't said. It was said that she came here with the president of the
That's
NAACP.
not what I heard.
That's exactly what was said.
Anyway, she's not a member of the NAACP. She's just somebody that's in the courtroom. There was no improper contact. This man made sacrifices to be on this jury. Remember the vehicle and all that? He hasn't done anything wrong. He hasn't done anything wrong. There's no, I don't even know if she's been watching, I don't know if he knows she's even been watching the trial. So he says, I don't know what she's was doing out here. So she's not in any type of organization that Mr. Trevina should be concerned about. I don't see any reason why he shouldn't be able to continue being a juror.
All right. Is she in the courtroom right now?
No.
She would be in the overflow courtroom.
Oh, she'd be in the
watching
overflow
trial.
courtroom. I mean,
All right. Well, do we want to bring her in to see if she
Yes, Your
indicates that they didn't talk about the case?
yeah.
Okay.
Also, if we could approach Judge a little bit.
All right. Are we now ready for the jury?
We are.
Very good. Let's bring them in.
Your Honor, the jury is present and seated.
All right. Welcome back, members of the jury. Mr. Trevina, you may proceed with your closing argument.
Thank you, Your Honor. Good afternoon, members of the jury. Your right to stay alive is the most fundamental and natural right a person has. In the case of self-protection, that is on an important, fundamental, and natural right that all humans share. A person's sovereignty and their ability to protect themselves is the most important thing. And everything else after that you can debate about later. Ladies and gentlemen, Those were the words of the state's own expert. They called him to the stand, and he told you that that's what he has posted on his own website. And we couldn't more wholeheartedly agree that that is all accurate and correct. Obviously, you know this case is hugely important. We live, unfortunately, in dangerous times in this country. America is the greatest country on earth. But the country has issues, problems. It's unfortunate that people find the need to have to carry firearms to protect themselves. But it is the will of the people that that be permitted, not the minority view, but the majority view. That's why states allow individuals who have the proper training. Unfortunately, in Florida, it's only a 4-hour course that allows them to carry a concealed weapon. Why would you carry a concealed weapon? For self-protection. It is a basic, fundamental, constitutional right that we all share. It is equally fundamental that a person has, in addition to the Second Amendment right to bear arms, that they have a right in this United States to have freedom of speech. That's our First Amendment. These are basic core concepts of our Constitution here in this country. You have a right to speak if someone does something that's offensive. You don't have a right to attack them, but you have a right to talk to them. And that's what Mr. Drejka did. He exercised one of his fundamental constitutional rights to talk to someone who was violating the law by parking in a handicapped space. Now, you may think that that's a minor issue, it's not really that important, but to some people that's extremely important. Handicapped individuals are a protected class in this country. And you heard during jury selection where one of the potential jurors indicated that, more than one potential juror indicated, that it was such a significant issue to them personally, their pet peeve, that they couldn't even be a fair and impartial juror in this case. That it would cloud their judgment in hearing the evidence, that if they learned that someone had parked in a handicapped space that wasn't handicapped. I'm sure you all recall that. And one gentleman actually worked as a parking attendant and said that he is constantly in disputes with individuals who park in handicapped parking spaces. This is not unique to Mr. Drejka. There is a significant portion of the community that finds that extremely offensive. And he just engaged in his basic fundamental constitutional right to speak to that individual. He never touched her vehicle. At all times, and you'll watch the video, he was at least several feet away. The video speaks the truth. You need to watch the video, and I'm sure you will when you go back and deliberate. The reality is that I have a very serious concern in this case that you will be able to reach a unanimous decision. Why is that? Well, you heard Dr. McLean say that this case is very divisive. We all know that. There are obviously different opinions. Everyone that watches the video seems to come away with a different opinion about what it...
Your Honor.
Stand.
All right.
Totally improper.
When you watch the video, you will be needing to make a decision as to what you, as an individual juror and as a collective group, find to be the facts, the truth in that video. Well, what do we see in that video? We see Mr. Drejka exercising his right to complain to this individual, Ms. Jacobs, about parking in a handicapped space. Could have ended easily with her just saying, "I'm sorry, I'll move the car." She wouldn't do that. You heard her say, she said she was not going to move the car, that she was going to wait until her man came out, and that she would then leave. Mr. Drejka indicated to her, what you're doing is illegal. You're parked in an illegal spot. The conversation became more heated, but if you remember Ms. Jacobs when she testified, she said there were no curse words, no epithets, nothing of that nature. It was just a heated conversation back and forth. She's telling him, mind your own business. Mind your own business. He's saying, well, what you're doing is wrong. Nothing illegal about that conversation at all. When he approached the vehicle, you heard him say in his interview to the police detective, he didn't even know there was individuals inside the car. It wasn't until he had circled the car and gotten in the front of the car that he realized that Ms. Jacobs was behind the driver's wheel. There's no way he could have seen the children in the back. So the idea that he was doing this to someone who had children in the back of the vehicle as passengers is absurd. You have the defendant's own statement to law enforcement, where he indicated he thought the car initially was empty and then realized there was an occupant in the vehicle. He didn't do any damage to the car. He didn't vandalize the car. He didn't make any threats. And you heard Ms. Jacobs say that. He never threatened her. She just felt threatened by his presence. That is what's unreasonable, because someone comes up and says, you're in a handicapped parking space. And was she really threatened? Think about it, ladies and gentlemen. Was she really threatened? Because you heard her concede only on intense cross-examination from Ms. Coy that she said she was going to get out of the car and she wanted to put hands on him. That came from the witness's own mouth. She wanted to put hands on Mr. Drejka. And that's exactly what her plan was. She was waiting until her man came out. And remember, we have multiple witnesses, including Ms. Jacobs, including Mr. Drejka in his interview, where she indicated she wanted to put hands on him. That's very important, because it shows her intent to cause bodily harm to Mr. Drejka, and that was in his mind when he learned she was going to put hands on him, that she was now a physical threat to him. And she also made the statement, depending on which witness you hear, it was either the effect of, wait till my man comes out, he's going to handle you, or he's going to F you up. It doesn't really matter whether she used an expletive or not in describing it. But she clearly said, not only did she want to put hands on him, that Mr. McLaughlin, when he came out of the store, was going to attack him. She already knew that. She said, wait till my man comes out. He's going to handle you or he's going to F you up. That's already knowledge that Mr. Drejka has in his mind. And what happens next? He never even seen Mr. McLaughlin coming. He's standing there speaking to Ms. Jacobs, and he's shoved violently to the ground with so much force that he lands on his bottom on the asphalt pavement, bounces a little bit, and he's laid out flat. You heard him say, and the video shows, that he struggled to with his arm now injured, his shoulder now injured, his right arm, his gun hand. He's reaching around to retrieve his firearm, and he's able to finally do that, but he needs to use his left hand now because he's been pushed to the ground. His arm hurts, he's in pain. He uses his left hand to steady his aim, which you will see on the video. There may be some movement of the gun. The state's trying to make you think that that's him trying to direct him with the gun. That's ridiculous. No one ever said that before this trial, that he was trying to direct him. When the police investigated, that was never an issue that came up. But now suddenly that's an issue in the case when they go frame by frame and look for any jitter or jumps. They're going to use anything and everything they can to try to get a conviction in this case. Use your common sense. I think Mr. Rosenwasser made a fatal mistake in his closing argument to you. He told you that essentially that by Mr. Drejka pulling the gun, that was legal. He had no problem with Mr. Drejka.
Your Honor, I would object. That's a mischaracterization of the closing and a misstatement of the law.
All right, well, I will instruct the jury to please rely upon your own recollection of what the lawyers may have said in closing argument, what the evidence in the case was, and obviously follow the instructions that the court gives you. All right, you may continue.
Thank you, Your Honor. Mr. Rosenwasser said that he had no problem with Mr. Drejka pulling the gun and pointing the gun at Mr. McLaughlin. I'm sure you heard that, but as the judge said, rely on your own recollection. Here's the fatal flaw in that argument. Everyone knows, common sense says, you don't pull a gun unless you're going to use it. He's trying to separate the acts into separate events. It's all one event. He pulls the gun, he steadies his hand, he aims, and he fires. All one event, not separated in time like the state wants to make it. Why is that important? Because he's absolutely correct that it was perfectly appropriate, justified, and legal to draw that firearm after being viciously slammed to the ground by Mr. McLaughlin. None of you should have any issue with him pulling the gun after that happened. The state wants you to separate that from his pulling the trigger and say, well, that's where it became a crime, when he actually pulled the trigger. And they're going to try to argue to you that Mr. McLaughlin made some movements that were indicative of a retreat. And in fact, Ms. Jacobs tried to say, well, yeah, he was retreating. Yet Ms. Coy on cross-examination revealed that she never said that before this trial, never used the word retreat before. That only came up here during the trial. What Mr. McLaughlin was doing, and again, that's why it's not up to an expert to decide, it's up to you to decide. What happened when that event occurred, when Mr. McLaughlin was shot? Reasonable people, and I'm hoping that you see what we see, do not see a retreat. When you watch the video, and if we could play the video, please. Mr. McLaughlin comes out of the store, starts to accelerate his pace, boom, slams him to the ground. All in one motion. And you've got all these individuals. Let's stop there. Look who's there as he's retrieving his firearm. You see Mr. McLaughlin there? He's hiking his shorts up. That is an aggressive move. That is, I'm ready to fight you. I'm hiking my shorts up. I'm getting ready to engage in combat. That is not a retreat. Mr. Drejka knows that he's just been blindsided. There are 3 individuals now in his field of vision. You've got Ms. Jacobs, who already threatened that she was going to do violence. You've got Mr. McLaughlin, who clearly just did violence. And you got both of them approaching Mr. Drejka. It wasn't until he pulled the firearm and then fired that everyone dispersed. Go ahead and play it through. That is one event. That's not to be broken down frame by frame, because the human eye doesn't see things frame by frame. As Dr. McLean told you, that when someone is in that situation of extreme stress, physical attack, you heard the one potential juror say in jury selection, he was attacked, and the next thing he remembers is the guy.
Object to that. Referring to what people said in jury selection is not evidence.
All right, well, I'll overrule the objection. I mean, it was something that was said during the trial. Go ahead.
That he was, the next thing he remembered was a gentleman was at the bottom of the stairs. Obviously, he didn't get there by himself, but he couldn't even remember pushing him or fighting back. That's what high-stress situations do to a person. You don't always remember. You might not remember accurately. And you remembered Dr. Bedard say in his testimony that when you are under such a high-stress situation, like with law enforcement officers, you should wait 24 hours before you even do a detailed interview with them. There's a reason for that, because they're traumatized after firing a weapon. You watch Mr. Drejka in this afterward. Go ahead and continue. As Mr. McLaughlin goes back into the store, he keeps his firearm trained on him because he doesn't know if he's a continuous threat, which is what one would expect when you're trying to see if there's a threat. As soon as the threat is over, he puts the firearm down. He didn't shoot Brittany Jacobs. If he was so much wanting to use that gun. The state wants you to think that he's just a person out there. I think he said a vigilante. Does he look like Charles Bronson in Death Wish? I mean, come on. This is not a vigilante. This is a person who was viciously attacked and responded appropriately. How is that not reasonable if you're shoved with that kind of force to the ground? Common sense tells you that he could have suffered serious, if not fatal, injury from such an event. When you're shoved with that kind of force, he could have fell on his head, he could have broke his neck, he could have broke bones. That's an aggravated battery or a felony battery. There are two different crimes in Florida that would fall under the actions of Mr. McLaughlin. He committed felonies against Mr. Drejka. The state doesn't want you to think about that. They want you to think, oh, he's a kind man who was high on a love drug, who was just going out to be peaceful. What was he going to do, hug him? Come on, use your common sense. He wasn't going to go out there to hug him. And you heard what Dr. Buffington said about the effects of MDMA and MDA. Both were in his system. Two separate things. One could be a metabolite or it could have been a separate drug. Very, very chemically similar to methamphetamine. We know it's
Your Honor, I would object. That's a mischaracterization of the evidence.
All right, again, please rely upon your own recollection of what the facts are. You may continue.
Thank you, Your Honor. That's what was going on. You had someone who didn't even have a small amount. You heard it was 459 was the number. 75 is a therapeutic, high therapeutic dose given in clinical trials. He wasn't at 75. He was at 459. There we go. There's the chemical makeup of methamphetamine, and as Dr. Buffington clearly explained, on the left is another molecular group that changes it to MDMA and MDA. Very chemically similar, almost chemically identical. So to suggest that it's not is ridiculous. So you have this individual who comes out of the store, he's under the influence, he viciously attacks a man. Mr. Drejka doesn't know who this person is. He has no idea. All he knows is Brittany Jacobs said, my man's going to come out and take care of you, in so many words. Well, that's exactly what happened. And she wasn't getting out of the car to give him a hug either. She was getting out of the car, she admitted. She intended to put hands on him. So you got two people there. And then you got Mr. Castelli looming around. What was he going to do? Was he going to intervene in this? We don't know. Mr. Drejka certainly didn't know. All he knows is he's standing there engaged in a legal conversation with someone, and he's suddenly on the ground. He pulls his firearm. He fires. The law says that that is excusable. The law says that that is self-defense. And we're going to talk in great detail about that in a few minutes. I've got an hour and 45 minutes total, but I don't think I will take that much time. Let's talk about the specific witnesses in this case. State first called Richard Kelly. He's known as what's called the Williams Rule witness. The state wants you to think that Mr. Drejka engaged in some bad act in the past and that this somehow should influence you in your decision in this trial. I would suggest to you that that is not the case for a number of reasons. If anything, kind of supports the defense because Mr. Kelly wasn't shot. If someone was looking to shoot someone, he would have displayed his gun, he would have threatened the gun. Mr. Kelly told you none of that happened. He never saw a gun, never knew anything about a gun. Mr. Tyler later claimed that Mr. Drejka said, well, I would shoot him, or I should have shot him, or something to that effect. Well, it's convenient now that he would say that. Where's the recording? Where's the proof that conversation ever took place other than Mr. Drejka admitting he called his boss? And what did he say? He said he complained about the employee's attitude. He wasn't hiding anything. He wanted the boss to know what his employee had done. He wanted him to know how rude he was. We know Mr. Kelly lied to you. There were two lies he told. Mr. Kelly tried to tell you that he didn't know that there was a shooting at the convenience store. Well, how do we know that's a lie? His own boss said he heard the shot and they were talking, and the boss, according to the boss, said, you should go over there. So why would Mr. Kelly now say, oh, I didn't even know what had happened. I just saw a lot of police vehicles, emergency vehicles. I knew something happened. There was crime scene tape. but I really didn't know it was a shooting. And I saw Mr. Drejka's car there. Think about that. Why would he lie about that? Because he clearly did. He tried to tell you he didn't know it was a shooting. His own boss said he heard the shot and he told him. What else did he lie about? He said that Mr. Drejka was basically doing all the talking in the argument, that he was the one that was the aggressor and rude and so forth. Well, what's interesting is you heard from Abdullah Salas, the owner of the store. He didn't say anything like that. He said the opposite. He said it was Mr. Kelly who was the primary voice in that dispute. Mr. Kelly was the one that was shouting. Mr. Kelly was the one that was upset and angry. Mr. Kelly was the one that was using curse words, swearing at Mr. Drejka. And what else did Mr. Salas tell you about Mr. Drejka? He said he's a routine customer in that convenience store, comes in there every day. Well, if Mr. Drejka was this vigilante parking lot cop that the state wants you to believe, why wouldn't there be a whole multitude of incidents at that convenience store? Why just one many months prior to this incident? Again, use your common sense. There's no evidence that Mr. Drejka was going around monitoring the parking lot like the state wants you to believe, sitting there waiting for someone to pull into the handicapped parking space. They want you to believe that. They're trying to make that argument, but use your common sense. There's no evidence to that. Mr. Kelly wasn't shot. And you also heard, through evidence in this case and through Mr. Drejka's statement, that he's been carrying a firearm for over 25 years. You think if somebody was itching to use their gun in 25 years, if you really, that was your motive, your agenda, you wouldn't have found someone in 25 years' time? No.
Maybe we approach.
And remember in that interview as well, that Detective Moffat, who interviewed my client, he said he would have pulled his gun as well in that circumstance. Review that video in detail. We're going to get to these instructions here in a moment. We're going to talk about some things that were not read by the state that are relevant to this case. Now, we've talked about Ms. Jacobs. My man's going to handle you, wanted to put hands on Mr. Drejka. And then we had Vicki Conrad testify for the state. She said something that was important. She said that inside the store, you could not hear what was going on outside, that there was no argument that was carrying over to inside the store, that she didn't know anything about what was going on outside until it was, let's see. Mr. Castelli came in and said something to the effect, and this is important too to review. He said that, because his testimony changed, obviously, and I'll let you determine how important that is, but he said that he saw something in the parking lot. There's something going on out there. He never used the word altercation before. He just said somebody should go outside, there's something going on. Very nondescript, whatever version you want to believe. It was very nondescript. So it wasn't like he came in and he said, oh my God, somebody better get out there. This man's attacking this woman, or he's threatening this woman. Nothing like that whatsoever. He just poked his head in and said, there's something going on outside. Somebody should probably do something about it. And then Mr. McLaughlin's response is to leave his 5-year-old inside the store, to go outside, as you've seen on the video, to continue to accelerate as he approaches Mr. Drejka, who doesn't see him, and to shove him to the ground. You've heard from various detectives in this case. All of them said, every one of them, that Mr. Drejka was courteous, compliant, did everything that was requested of him, cooperated fully. He didn't say, I want a lawyer, get me a lawyer, I'm not going to talk to you. He didn't resist. Even after the shooting occurred, Think. He went to his vehicle, secured the gun, and waited. Waited for the police to arrive. He didn't try to flee the scene. There's no argument here of consciousness of guilt that he did something wrong. It was quite the opposite. He was inviting the detectives, inviting everyone, make sure you look at the video. You'll see it was self-defense. He told them how he was attacked. He didn't try to run away. He gave a full, detailed statement. He sat over 6 hours at the sheriff's office in that little interview room, even though there was only an hour of actual interview that it's now been, all the dead time has been cut away, so you don't waste your time for 6 hours just sitting, watching him sit there. But he was there for that whole length of time. He didn't say at any point, look, guys, I got to go. I got family at home. I got to go home. You don't hear him say that. He would sit there and cooperate until the detectives were satisfied they had completed their interview of him. Would a guilty person do that? Would they say, I'll waive my Miranda rights and give you a full statement? I'll sit here 6 hours. I'll wait until you're happy, till you've heard the whole story, till you've heard the truth. That's what happened. And at the conclusion of that interview, he was allowed to leave. Now, we had some technicians that came in, took some photographs. That's what I always call the prosecutorial dog and pony show, because in reality, all of that could have been stipulated too. We didn't have to have technician after technician come in and put in evidence, but they want you to think the case is more important for the state. They want you to think, wow, look at all the time we've put into this case. That all could have been brought in. We didn't object to any of that. Could have put all that in without having all these witnesses, having you sit here all that time, listening to people go through the chain of custody to enter evidence in. No one disputed. It's on video that he shot this man. Yes, he did. Why do we need all these witnesses to come in and talk about the video and how it was secured and all these various people? Think about that. Think about, are you being manipulated? What really is relevant here? It's all on video. Why not just show the video?
Your Honor, may we approach?
Okay.
You also remember that in that same vein, the FDLE agent came in, the technician, to talk about the firearm. Again, no one disputes that it was Mr. Drejka's gun that fired the bullet, but he couldn't even match it. Do you remember that? He said he couldn't get a conclusive match between the firearm and the round that was retrieved. Just interesting. He also said some things that I'm sure you remember about the trigger pull. He never even measured it. He said he wasn't skilled to do that. Why didn't anyone even check the force necessary to pull the trigger? Why is that relevant? Because if it's a lighter pressure required, that should be something you should consider. You know, this wasn't something where we don't even know. That's doubt as to what even the force was necessary to pull that trigger in this case. Something simple like that, they never produced for you. Another thing you need to consider in this case is that there was only one shot fired. If someone was so gun happy that they wanted to shoot someone, wouldn't they have emptied the whole clip into them? Why would you only fire one shot? Because he was trying to do what was reasonable under the circumstances. There was a threat. He terminated that threat by firing only one shot. He wasn't even sure, if you remember from all the statements of the witnesses and his own statement, whether he'd even hit Mr. McLaughlin. He didn't know. He even asked, did I hit him? Is he okay? If this was such a vigilante who wanted to go out and shoot someone, why would he ask the condition of the victim? Why would he show remorse, as you will see in the video when you replay it, when he found out that Mr. McLaughlin had expired. He didn't sound happy about that. You'll see that he looked very sulked and sullen when he heard that information. He didn't even know if he had shot him. That's important for you to consider. And it's also important that it was just one shot. He did what was reasonable and necessary under the circumstances. There was a threat posed by 2 or 3 individuals in his presence, and he reacted the way that he saw fit and reasonable under the circumstances. And remember that it's kind of a mixed standard under self-defense. It's not only objective, what a reasonable person would do, it's also subjective through the eyes of Mr. Drejka. You have to look at this case through his lens, not what you would do as a juror, not you individually, what he did under the facts and circumstances of this case. That's the way you must conduct the analysis. You heard in his interview that he had discussed technical terms, and the state makes a big deal of that. Well, you know, he talked about force multiplier and 21-foot rule. Well, first of all, we don't know what his training was. We know he had a concealed weapons permit, but he's had that since he was 21 feet. But apparently, someone in law enforcement named Tuller did a study on how long it takes to react to a threat. Doesn't matter what the threat is, whether it's a knife, or in this case, in Mr. McLaughlin, it was his hands and feet were the threat. And we clearly know he could use them with great force. 21 feet. That threat is considered viable. He was clearly within 21 feet. He was in a much closer proximity, much less distance than that. So why would it be unreasonable for Mr. Drejka, with that individual standing within that close proximity, to use his firearm? Look at the disparity between the physical makeups of the 2 individuals. And the judge will tell you in the instruction that you can look at the disparity, the relative physical abilities and capacities of Michael Drejka and Marquise McLaughlin. That's in the instruction itself, that you must consider that in your deliberations. The relative physical abilities and capacities. Mr. McLaughlin was in his 20s. Mr. Drejka, late 40s. Mr. McLaughlin was 205 pounds and 6'1". You can see from the video, very muscular build, very athletic looking person. He wasn't disabled in any way. Mr. Drejka, he complained of health issues with the police detective. He said he had never fought before. He'd never been in a fight, even in school. He's not a fighter. This is not an individual who goes around beating on people. He did not have the physical capacity to defend himself against such an aggressor. Relative physical abilities. Mr. McLaughlin was the weapon in this case. Nowhere in the law does it say that the assailant has to be armed. The state wants to infer that to you. They want you to think that Mr. McLaughlin needed to have a weapon of some sort for it to be justifiable for Mr. Drejka to use deadly force. That's not the law. The law says clearly, in deciding whether Michael Drejka was justified in the use of deadly force, you must consider the circumstances by which he was surrounded at the time the force was used. The danger need not have been actual. You know, remember Mr. Rosenwasser, we went over that? He didn't read that part. The danger need not have been actual. Think about that. It's what his perception of the danger was. Need not have been actual. So even if you find in your own deliberations, I'm not sure if he really presented that much of a threat. I don't know how you could find that given he was slammed to the ground in such a violent manner. But even if you were to find that, it doesn't matter. What matters is what Mr. Drejka thought.
Your Honor, I object. This is the 3rd mischaracterization of the law. May we approach?
Well, I have already instructed you on the law. You have a copy of the jury instructions. Please rely upon the instructions that I gave you. You may continue.
Thank you, Your Honor. Based upon appearances, Michael Drejka must have actually believed that the danger was real. Mr. Drejka must have believed that. Well, clearly he believed the danger was real. He reacted to that danger. The danger was real. This large man had just violently pushed him to the ground. How could you have more real danger than that? Fear. Mr. Drejka was in fear. That's the whole point of having a concealed weapons permit, is to defend yourself if you're attacked. You don't have to be attacked with a knife or a gun, as the state's trying to suggest. You're not going to see that anywhere in any of the instructions. They can't argue that. Not directly, because you don't have to have a weapon to use lethal force to defend yourself. Mr. Rosenwasser said repeatedly that, well, what did you think? He was going to beat him to a pulp? That's exactly what the two of them were going to do. They were going to beat Mr. Drejka to a pulp. He had started it, Mr. McLaughlin. Ms. Jacobs had come out of the vehicle. That's exactly what they were going to do. They were going to beat him to a pulp. Mr. McLaughlin hikes up his shorts, takes a fighting stance, blading, aggressive posture, whatever you want to call it. You make the call on what you see in that video. But remember, Mr. Drejka didn't have the luxury of rolling it back in slow motion to see frame by frame what occurred. That wasn't an option for Mr. Drejka. Mr. Drejka was already on the ground in pain, having been violently attacked, a felony attack on him. And he used the only means of self-defense that he had. What would have happened if he hadn't have pulled the gun? He would have been beaten to a pulp. He may have been killed. They want you to think that this was, what was one of their experts said? That it was a schoolyard push. I've never heard anything more ridiculous in my life. Look at that video. Does that look like a schoolyard push to you? He comes at him with a palm strike, charging at him with full force, using his 205 pounds of body weight to slam him to the ground. Mr. Drejka, look at him. He's 5'10", 173 pounds.
Objection, Your Honor.
Facts not in evidence.
That's right.
Sustained.
All right, well, Mr. Drejka, you just stand for the jury so they can see you. Thank you. Make your own judgment. The relative physical capacities of the parties is a situation, it's an issue you must consider in your deliberations. Mr. McLaughlin was the weapon. And not only was he a weapon that had the appearance of the threat, he carried out the threat. He attacked him. This would have been different if Mr. Drejka had actually turned and saw Mr. McLaughlin coming and then pulled his weapon and fired. It'd be a different situation. It's not what happened. It's not a schoolyard push. It's not a tap. Even Mr. Rosenwasser admitted it wasn't a light tap, but he wants you to think it wasn't really that big of a deal. Oh, Mr. McLaughlin, he was only defending his family. Really? He's defending his family when he leaves his 5-year-old in the store? He's defending his family when he goes the opposite direction after he's shot and there's a man with a gun there? Does that make any sense to you? Of course it doesn't. And why did Mr. McLaughlin act that way? You heard from Dr. Buffington why. Common sense tells you why. If you're high on a drug, an extreme level like Mr. McLaughlin was, 459 is the reading. 75 is the therapeutic, high therapeutic level. You heard from Dr. Buffington. Some cases, people do have euphoria, increased sensory perception, but in other cases, they become agitated, paranoid, irritable. Those are side effects of the drug, especially in the quantity that was found in his system. That explains why he went up and attacked a man without saying anything. Wouldn't a reasonable person who wasn't high would come out and say, and by the way, he's riding around with his kids while this high level of MDMA in the system. But wouldn't a reasonable person have come out of the store and said, what's going on here? What are you guys arguing about? What's this about? Wouldn't he ask his girlfriend, what did this guy do? What's going on? Did he touch you? Did he do anything to you? He doesn't inquire at all. He goes straight beeline for the attack. Not a word. It's bizarre. I give you, it's very bizarre. But it's explained by the drugs. That's why it happened that way. Should Mr. Drejka have to suffer now because Mr. McLaughlin decided to get high on MDMA and couldn't control his behavior? It wasn't Mr. Drejka's behavior that's an issue, as much as the state wants you to think. It was Mr. McLaughlin who had the problem here. It's Mr. McLaughlin that decided to put hands on first in this situation. Mr. McLaughlin was the cause of his own death. It's unfortunate, but remember, feelings of sympathy are not to be taken into consideration, but even the judge is going to tell you that. So it's not about sympathy. Mr. McLaughlin caused his own death by violently attacking a man with no justification, no provocation, because he's talking to his girlfriend. The state wants you to believe, oh, he's defending them. He's defending them. If Mr. Drejka had not pulled that firearm, we'd have a whole different situation here, because who knows what would have happened to Mr. Drejka. And now they want you to think, oh, he's just defending his family. They're not talking about the significance of his drug use and his actions here, his unprovoked actions. You also hear in the instructions that under Florida law, there is no duty on the part of the defendant to retreat. And this is where we hear the stand your ground language. In Florida, the defendant has the right to stand his ground. But in reality, where was he going to go? He was already slammed to the ground. He's in a very vulnerable position on the ground. He didn't ask to be attacked. Certainly by having a discussion with someone about a parking space, does that deserve a violent felony attack against them? Of course not. He had a right to stand his ground and no duty to retreat. You heard the state talk about, under the manslaughter instruction, everyone has a duty to act responsibly toward one another. Well, that also includes Mr. McLaughlin. They want you to focus on Mr. Drejka, but not Mr. McLaughlin. But Mr. McLaughlin had a legal duty not to commit a felony attack on Mr. Drejka. That's important for your consideration in this case. Now, I don't expect you to go back and have favor one party over another in this case. It's not about who you think is most popular or who you think should pay for what occurred that day. Because under the law excuses his conduct. The law justifies his conduct. Because in addition, and Brian or Will, do we have the instruction on manslaughter?
Yeah.
Yes. Every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. You have to consider that. Is what the state's alleging is he negligent? It's not the standard. You can't convict if you think he was negligent in doing it. If you think maybe his perceptions were off, maybe you think, well, I'm not so sure. That's reasonable doubt if you're thinking that. If you're troubled by the facts of this case, if you're not certain, if you don't have an abiding conviction of guilt, the judge will instruct you, you must find Mr. Drejka not guilty. Abiding conviction of guilt, or if you have one, if you waver a little or vacillate, and you think, I'm not so sure, I'm definitely not convinced, so sure, then you must, under the law, find Mr. Drejka not guilty, because the state hasn't proven its case to you beyond a reasonable doubt. And remember, under the self-defense instruction, do we have that one?
One second, I gotta get that out.
I have it in my jury instructions here, yeah. before I get to the self-defense, because it's actually part of the justifiable homicide instruction. Part of that justifiable homicide instruction says the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant. And then it goes into a house, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Well, this is not a dwelling, but clearly there was a felony committed upon him, and the law says justifiable homicide in itself. And then you go to the self-defense instruction, and that says, it is a defense to the crime of manslaughter if the actions of Michael Drejka constituted the justifiable use of deadly force. Deadly force, of course, means any force likely to cause death or great bodily harm. Michael Drejka was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself, and he had no duty to retreat and had the right to stand his ground. You're going to get that instruction when you go back in the jury room. In considering the issue of self-defense, you may take into account, we've already discussed that, the relative physical abilities and capacities. The danger need not have been actual. We've discussed that. It's whether Mr. Drejka believed that the danger could only be avoided through the use of deadly force. Michael Drejka must have actually believed that the danger was real and the defendant had no duty to retreat. If in your consideration of the issue of self-defense, and this is crucial, you have a reasonable doubt on the question of whether Michael Drejka was justified in the use of deadly force, you should find him not guilty. So the burden is on the state to prove it wasn't self-defense. Remember that. The defendant in any criminal case is never required to prove anything. We could have sat mute throughout the entire trial if we wanted to. He's not required to prove or disprove any fact in this case. But we did present a defense. And if you have a reasonable doubt as to whether he used self-defense, you may think it wasn't appropriate. You may go back and say, I'm not so sure if this was really a self-defense case. That is reasonable doubt. You must find him not guilty. If you're not sure, if you're not 100% convinced, if you don't have an abiding conviction of guilt that it was not self-defense, then you should find the defendant not guilty. You can see the instructions. This is the law. What I say isn't the law. What Mr. Rosenwasser says isn't the law. This is the law as the judge has already instructed you, and you will be able to take these instructions back to the jury room when you deliberate. And remember that this week-long trial, and all these hours we've been talking about this case for this entire week, what happened occurred in a matter of seconds. 11 seconds in totality from the point that Mr. McLaughlin was at the store and came out. 4 seconds in the time that he was attacked, retrieved his firearm, and fired. Seconds. Not a week, not hours, not minutes. A matter of seconds. And remember what Dr. McLean said. The emotional and physical issues that are involved in a situation like this can alter a person's perceptions. It's common sense. You really don't need an expert to tell you that. If you get slammed to the ground, you're going to have consequences from that, physical and emotional. Think about that. Mr. Drejka obviously had some injury to his right arm. You can see it in the video. It's difficult. The state wants you to think, I don't know, that he's faking it or something. I don't even get that. But clearly, he had an injury. I mean, someone gets hit with that kind of force, you're going to have an injury. And he did. And we showed you the shirt. It showed the scuff mark on the sleeve. He went down hard on that pavement. The good thing in this case is we have the video. We're glad we have the video, because the video proves his innocence. We don't have to prove innocence. All we have to show is that there's a reasonable doubt as to the issue of self-defense or justifiable homicide. If you have a reasonable doubt, you must find the defendant not guilty. talking about 3 to 4 seconds from the time the gun was pulled to it being fired. Remember also that Mr. Drejka was wearing sunglasses. We brought that in as evidence. So that's obviously going to have an issue too, because it darkens his vision, whatever impact you think that may have in this case. Also remember that the vehicle's windows were tinted. It wasn't until Ms. Jacobs actually began questioning why the defendant was there that he even realized someone was in the car, as he said in his own interview. This case is not about murder or premeditation, even though some of the state's arguments seem to imply that there was some motive. It's not about that. It's a manslaughter case, and it's a self-defense and justifiable use of deadly force case. So anything about prior incidents or any of that is really irrelevant in the end. What's relevant is what happened in this video, the scene in the video, on that day, July 19th, 2018, in the afternoon. That's what's relevant. Reasonable doubt in a case, as a judge will instruct you and has, can come from the evidence, the lack of evidence, or a conflict in the evidence. We've seen the conflicts in the evidence, how people have somewhat changed their stories over time from when they gave initial statements to when they testified in court. Why? You have to ask yourselves, why would the stories change? Why would it become more aggravating as time went on? Wouldn't their statements at the time of the incident be the freshest in their mind and the most accurate, rather than what they come in over a year later and tell you? That's why those earlier statements, when we call it impeachment, when you saw us using police reports and prior depositions, because those were back in time. Police report was interviews that occurred on the day of the incident or a day after, not a year or more later. It's important for you to consider as well. Why did these stories become different? We keep hearing about, and the state wants you to believe that this case is about a parking spot. Really has nothing to do with a parking spot. Mr. McLaughlin didn't know what the case was about. He didn't know what the issue was when he came out of that store. He didn't know it was over a parking space, and he didn't stop to find out. All he knew was he was going to attack Mr. Drejka. So I think it's disingenuous to keep saying it's about a handicapped parking spot. It isn't. It's about the reaction of a man, Mr. Drejka, who was violently attacked by another man. Mr. McLaughlin didn't know anything about a handicapped parking space. He didn't know what the argument or dispute was about. Never stopped to ask. He was going to put hands on Mr. Drejka and did. Brittany Jacobs wanted to put hands on Mr. Drejka and was about to. And then you have Mr. Castelli looming in the background. We don't know what he was going to do. When you consider self-defense, and you have that instruction, you must consider all the surrounding circumstances. The danger not be actual, as we've discussed. And I think it's important to reiterate again, life doesn't happen in slow motion. When you watch the video, watch it in real time. You can watch the slowed down version, but is that really representative of what Mr. Drejka was perceiving? We don't see things in slow motion, as Dr. McLean said. The state wants you to believe that we do. And somehow the cross-examination implied that we have this mental ability to slow down time. Wouldn't that be wonderful if we could? But that's an illusion that some people experience when they talk about, as Dr. McLean said, after the event. Well, it felt like slow motion. That doesn't mean they perceived it in slow motion. I mean, that's absurd. We all know human brains, we perceive things in real time. We don't have the capability to go into slow motion mode. If we did, we wouldn't need slow motion mode for various sports games, as Mr. Schaub kept repeatedly bringing up. He uses the football game example. Well, we wouldn't need, if we could see in slow motion, referees would be able to make the calls without making errors, because they do. It's their perception. Referees routinely make errors in calls. We see it anytime we watch a sports game. They play it back in slow motion and say, referee was wrong. That doesn't mean that the referee was lying. That doesn't mean that the referee was being bad or trying to pull one over on you. It just means that people perceive things differently, as Dr. McLean said, even if they're not in a stress mode. We all know that eyewitness testimony is one of the most unreliable forms of evidence that exists, because we all see things differently. And when you go back and watch that video I'm certain some of you are going to see it differently than others. So you have to ask yourself, if some of you see it differently than others, isn't that the very definition of reasonable doubt? If you can't all agree on what's on the video, how can you ever reach a verdict of guilty in this case? Every one of you would have to say, I see exactly the same thing. I doubt that will happen when you go back and deliberate, and I invite you to continuously look at that video. No one went back to the crime scene to measure distances. For some reason, they had the distance measured in the interview room. I'm still confused as to the relevance of that. I'm sure Mr. Shaw will come up and try to make some argument about it. But the reality is, no one measured how far away Mr. McLaughlin was. No one gave you any of those measurements. Why? Because they don't want you to know how close he was. Watch the video. You can see for yourself how close he was. Look at the shock that Mr. Drejka expresses after the shot is fired. He continues to train his weapon until the threat is gone. Didn't know if he'd been shot or not, didn't know what had happened. But he clearly, you'll see him fall to the ground for a moment on the video. Let's watch. Now watch Mr. Drejka. He keeps his gun trained on him. The threat is eliminated. Puts the gun down slowly. And he's keep running. You will have a lengthier one in deliberation. Watch his reaction. And watch his reaction when he finds out in the interview that Mr. McLaughlin had expired. He's not celebrating. He's not proud. He's not happy. That shows you that it wasn't his intention or his desire to take a human life. He did what he thought he had to do in the moment, in split-second timing, given that he was attacked. Another thing you need to consider when you do review the video, it's not a high-definition video. You heard their own experts say it was standard definition. We don't even know the age of the cameras that captured the images. But clearly, it's not the best images. And we heard about this compression artifact. You're going to see that there's some wavy lines when you watch the video in the deliberation room. You're going to see this little jumping, little wavy lines over the shoulder of Mr. McLaughlin at one point, on the grill of one of the cars at one point. So it's not completely representative of what occurred. And it's certainly not high definition representative. Color seems to be off, very, very low color. You heard the store owner say that Mr. Drejka came in every day. He didn't know he carried a weapon. Mr. Drejka never said, hey, I got a gun. I carry a firearm. Had no idea. And how did he describe Mr. Drejka? He said he was always calm. And in this video interview, he's calm. Seems a little depressed, calm. He doesn't seem proud or excited or anything like that. Very calm. Everyone that described him said he was calm, cooperative, a nice guy, not a bad guy. He hadn't been shooting in years. You heard in his interview, you'll listen to it again, I'm sure, that Mr. Drejka hadn't taken his gun shooting for many years. So he's not a gun nut. He's not somebody who has a whole room full of firearms and wants to use guns. He hadn't been shooting in years. Had his course, had his firearm concealed weapons permit for 25 years, more than 25 years, since he was 22 years old. Mr. Drejka said in his interview several times he had no time to think. He had no time to analyze the situation. He was attacked. He was blindsided. He says that. Listen to him in his interview. Those clips the state didn't play to you. Listen to them for yourself. Watch the whole video. he had no time to have the luxury that the state wants you to think he has now to analyze each movement and decide based on that. He made his decision based on what he perceived. He perceived a real threat. The threat clearly was legitimate. We've talked about that now. Mr. Bedard, as I said, he said police officers should, and when it's a law, and that's another thing too. The state keeps talking about police officers and security officers, and they're piling on you this confusion, the standard. Mr. Drejka is not held to the standard of a law enforcement officer. He doesn't have that kind of training. Law enforcement officers, obviously, as you heard from the testimony, have hundreds of hours of training. They give you 4 hours training and get a concealed weapons permit for 4 hours. It's not like a police officer. To say that he should respond like a police officer, you should know the same things that a police officer would know. This is ridiculous. He doesn't have that information. But I submit to you, and I want you to think about this, if he had been a police officer on duty, would we even be here? Come on, use your common sense. Would we even be here if he was really a sworn law enforcement officer in the same exact actions? No, I suggest we would not be here. The state wants to cherry pick certain statements that Mr. Drejka made and keep repeating those and replaying those to you in their argument. Look at the totality of his statements. They want you to think, I think Mr. Rosen wants to say, well, he lied about this and he lied about that. Or is that just the way he perceived things? Because he obviously gave a full interview and consented. People perceive things differently, as Dr. McLean said. Doesn't mean that they're lying. Doesn't mean the referee is lying when he said that a foul occurred and a replay shows it didn't. Doesn't mean he's lying. Doesn't mean he's a bad person. Look at the case through the perceptions of the defendant. And let's go through his interview. I'm not going to play the interview like the state did. I'm going to take a copy of the transcript, and you'll be able to review the video and back and be able to verify these things. He admitted that he had a pet peeve about handicapped parking spaces. He never denied that. He said that was his issue. And there was some discussion about a family member or family members who had disabilities. It's not a crime. You heard it in jury selection. Several people had issues with that. Very strong feelings. Not a criminal act. So he walks around the car. Not a criminal act. He looks for a placard. Not a criminal act. He engages in conversation with the driver. Again, not a criminal act. The first criminal act occurred was by Mr. McLaughlin when he came out of the store, high on MDMA, viciously attacking Mr. Drejka. That's what the case is really about. They don't want me to say that. They're probably twitching over there right now. They don't want you to hear about how he was high and how he attacked him. They want to focus on Mr. Drejka. Well, didn't you see this slight step or this step back? Why would you fire if he stepped back? Where other reasonable people see that as blading or taking an aggressive posture, hiking up the shorts, ready to fight, turning sideways to fight. These, as Dr. McLean said, are instinctive moves. Mr. McLaughlin was there to beat him. Do you really have any doubt about that? Mr. McLaughlin and his girlfriend were going to beat him. That's exactly what she said. She told the defendant, she said to Mr. Drejka, wait till my man comes out. And then she got out of the car as soon as she seen him. What do you think she got out of the car for? To hug him? She got out of the car because the two of them were going to beat him to the ground. Mr. McLaughlin started it. But, oh, the game changed when the gun came out. But it was too late. Because as I said, you have to consider that one entire episode, pulling the gun, firing the gun. It's one event. You can't break it down now. Is that fair to Mr. Drejka to break it down frame by frame and say, wait, you see this little spin he's making? He was retreating. If he was retreating, he would have backed all the way up right away. He wouldn't have attacked him to begin with if he was a reasonable person. Mr. McLaughlin came at him. When you put hands on somebody, there are consequences. You may think you don't like the law, you might not agree with the law, but you took an oath as a juror to uphold the law. You have to apply the facts of this case to the law in this case. And the law in this case says if you think Mr. Drejka perceived a threat, even if the danger wasn't real, but it clearly was, but if he perceived a threat and used lethal force to terminate that threat, which he did, the law allows that. And you might say,
Objection, that's a mischaracterization of the law.
All right, again, please rely upon the instructions by the court. You may continue.
thank you. And I encourage you, read the instructions. Read the instructions and make your decision based on the law and those instructions. But even if you don't agree with the law, you might think, oh, the stand your ground stuff in the instruction, and he doesn't have a duty to retreat. That's what the law is. That is what the law is that you swore as a juror to follow. You might not like it. You might think it needs to be changed, but that's for the legislature. That's a political move to change the law. And then if the laws change, the instructions change. But the law that you have today says what he did was justifiable, and it's also excusable. Why is it excusable? Mr. Rosenwasser said, well, it wasn't accident or misfortune. It was an intentional act. If you believe this argument that Mr. McLaughlin was actually retreating, you heard Mr. Drejka say that he thought he was coming at him still. His perception was he was still under attack. I suggest to you that the evidence can support that. But even if you found no, I think Mr. McLaughlin was going to back away and leave. He made the decision after he was attacked to use lethal force. If he was wrong in that decision, then that's the accident or misfortune. And if he has been provoked, because the law says provocation, if he had been provoked under excusable homicide, then you must find him not guilty. I may have a moment. If I may have a moment, Your Honor. So you have two pathways. Three things to consider, but two pathways to a not guilty verdict. You have justifiable homicide coupled with the self-defense instruction. You can't read this in isolation. You have to read it with the self-defense instruction. You have that pathway, and we've already discussed in detail why that should apply in this case. But even if you thought that shouldn't apply, you didn't think that if you don't have reasonable doubt about justifiable homicide, you still have this pathway. The killing of a human being is excusable and therefore lawful under any one of the following circumstances. When the killing is committed by accident and misfortune and doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Well, we clearly have that here. We don't have any unlawful action on the part of Mr. Drejka, and we don't have any unlawful intent, as much as the state wants you to believe. When the killing, and number two is very important, when the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. That's your second pathway. Because even if you found that you didn't think justifiable homicide applied, if he was wrong, if he was mistaken, if he was made an accident in deciding that the use of force was not self-defense in your mind, he still walks. He is found not guilty because the killing occurred upon sudden and sufficient provocation. He wasn't doing anything illegal, Mr. Drejka. The state's not going to argue to you that he was doing anything, he was committing any crime. They're going to argue that they think it's a bad act, and I don't know. They'll make their argument. But you need to consider the fact that if his perception was wrong, he's still not guilty because that's what he perceived. He wasn't.
I object. Again, it's a mischaracterization of the law.
All right, same instruction. Go ahead.
Thank you, Your Honor. And I was saying before, if you disagree with the law, and many people do, let's be real. There's a lot of people that are against self-defense, stand your ground. We hear it all the time. It's interesting that Mr. Bedard, Dr. Bedard, now, he's actually consulted on stand your ground law with at least 2 governors. He's a big proponent, as we discussed in cross-examination. It's on his website. That's their own witness. If you don't agree with the law, the place to change it isn't in this courtroom. The place to change it is in the legislature, not here. So Mr. Drejka says at his interview, "Dude, I haven't been hit like that since I was in my 20s. Okay, all right, so he shoves you to the ground. You fall to the ground? Correct. Okay, slightly dazed. Not very, slightly. He's being honest. He's not trying to play this up. He's not trying to say, oh, I was so discombobulated, I didn't know anything that was going on. Even though some people are like that, as we heard again in jury selection. Some people become so discombobulated, they don't even remember what happened. Guy ends up at the bottom of the stairs. I don't even remember doing it, but it happened. Okay, did you hit your head? Don't know. Don't feel anything. Okay, I don't know. So you don't know if he, Mr. Drejka says, went down sideways like this, and you know, this landed under my gun. Okay, so I landed on my wrist on my gun. Detective says, okay. Mr. Drejka had to reach over to extract my hand. You'll see that on the video. And he says, the detective, to push yourself back, Mr. Drejka, to push myself off of that. And as I'm reaching and pulling around, he's standing in front of me, and as I come up, he's taking a step towards me. Mr. Drejka perceived the threat as continuing. Okay, now let's discuss that if you don't mind. Could you sit on the ground for me? And he does a demonstration that you'll see. And he says, how far is the guy away? And he says, in front of the car, off the sidewalk. And then he gives his estimate that's about the length of the room. He said, so, and as I come up this way, because I have to come up off of my hand, all right, I bring the gun out with me, and as I'm coming back this way, I can't support it. And he says, okay. And he says, what does he do? He says, as I come out like this, he's taking a step. Okay, taking a step towards me. Okay, how close do you get? Does he get to you before you fire the gun? Maybe to the front tire. And he shows him again, he demonstrates. That was Mr. Drejka's perception of what was happening. And he goes page after page after page in excruciating detail. He's not trying to hide or conceal anything. He tells him exactly what he perceived was happening. And as I indicated, at the end of that interview, he goes home. And again, remember, Mr. Schaub's going to get up here. I don't have a chance to respond to Mr. Schaub. So I'm sure he's going to get up here and he's going to say, disregard everything Mr. Trevina said. He's a monster. You're going to hear all that again. He's a vigilante. He's Charles Bronson in Death Wish. I mean, these absurd arguments, because they don't really have any facts to support it. So I just hope that as you go back and deliberate on these extremely, fundamentally important constitutional issues, remember, we live in America. Mr. Drejka is presumed not guilty unless the state is able to overcome that presumption by evidence and testimony. We respectfully submit to you that that has not occurred in this case, that there is reasonable doubt. Common sense tells you that. We know how divisive this case is. Mr. Drejka did what he thought was necessary to terminate a threat a clear threat against his life. And as I said, when you go back and talk about it, ask yourself, if Mr. Drejka hadn't pulled the gun and fired, what would have happened to Mr. Drejka? As I indicated before, the burden of proof is on the state and state alone. We're not required to prove or disprove anything. And remember, reasonable doubt, proof beyond a reasonable doubt, is a very high burden. I want you to think of it, I always use the analogy in closing argument. It's like a measuring cup. It has little lines on it. And just kind of imagine this. When the trial starts, obviously the cup is empty. He's presumed innocent. There's no evidence against him. The first witness is the first evidence. And you have to remember, also, Mr. Kelly, who was the first witness, convicted felon. That's an issue that you can take into consideration. The judge will instruct you, and he already has, that if the witness has been convicted of a felony, you can disregard any or all of his testimony. And the same witness who participated in a vigil or vigils or marches regarding Mr. McLaughlin, ask what his motive is. Why did he lie twice that we know of? But getting back, this measuring cup starts out empty, then you go to mere hunch or intuition, certainly not a standard for conviction, reasonable suspicion, probable cause. None of these are proof beyond and to the exclusion of any reasonable doubt. Clear and convincing evidence, preponderance of the evidence, all these terms that are used in civil matters or for police to make charges against someone, the state attorney to bring charges, they're not the level of proof necessary for conviction. You got to go all the way up to the top of that measuring cup. It's just below the level of absolute proof, which is an impossibility, obviously. But the next level down is proof beyond and to the exclusion of any reasonable doubt. That cup has to be very full for you to have an abiding conviction of guilt and no reasonable doubt in this case. And I submit to you again respectfully, how could you possibly not have any reasonable doubt given all the multitude? I'm sure when you go back, you're all going to have different opinions about this video. Those of you who feel strongly that the state did not prove its case beyond a reasonable doubt, and there's one or two you may think otherwise, stand your ground. Don't cave into politics. Don't cave into agendas of others who want to change the law. Stand your ground and do the right thing, which is to call the state on this case and say, there's reasonable doubt. If such intelligent people think that there's reasonable doubt, how can you not think there's reasonable doubt? I may have a moment, Your Honor. So I'm going to close again with what I said at the beginning. Again, quoting Dr. Bedard. Your right to stay alive is the most fundamental and natural right a person has. In the case of self-protection, that is an important, fundamental, and natural right that all humans share. A person's sovereignty and their ability to protect themselves is the most important thing, and everything else after that you can debate about later. Self-preservation. Mr. Drejka was trying to preserve his own life, and unfortunately, to do that, he had to use lethal force. You may not like that, you may disagree with the law, but as I said, you've sworn as jurors to uphold the law. You have a duty to follow the law. And the law in this case says reasonable doubt. Now, whenever Mr. Schaub gets up here and says, oh, there's no reasonable doubt, it's obvious and this and that, use your common sense. Think it through. Mr. Drejka was the victim here. That's the sad part. The victim, the true victim, has become the defendant in a very serious criminal case. His life and liberty are at stake here on your decision. Think it through. One man is already gone. Do we want to take another man's life away from him on this kind of evidence when there's this kind of doubt in the case? Thank you for your time.
Thank you, Mr. Trevino. All right, members of the jury, we'll give you a brief 10-minute break, and then we'll finish up. All right, everybody be back at 3:20.
What time, Your Honor?
10 minutes, 3:20.